Good morning, please be seated. First case for oral argument this morning is 636, People versus Nelson Figuera. You're by yourself.
Good morning. Good morning, Your Honors. Alison McMahon on behalf of Appellant Nelson Figueroa. The order granting restitution should be vacated as it was not part of the bargain for sentence and it was not based on a valid out-of-pocket cost. The mother in this case requested restitution for rent
And I'm sure you're going to tell us that that isn't, that's not what restitution is. That
Yes.
This is something she wanted to get her unpaid rent and some bill that was coming up that hadn't even become due, and that's not restitution.
Yes.
Is that your argument?
Yeah.
I
that's
think
it.
we have
There's-
that.
Okay.
Thank
All
you.
right, thank you.
637, People versus Damian Morris.
Good morning, and may it please the court, Paul Dell for the appellate. Damian Morris did not receive a fair trial. Yes, we can blame Mr. Morris for that. And the prosecution does so in their brief. They blame him for his choices, and they blame him for not preserving issues for appeal. But even defendants who choose to proceed pro se are entitled to a fair trial. Whether or not represented by counsel, all defendants are entitled to due process
We
and a fair
understand
trial.
that, obviously.
Okay. As the court knows, guilty verdicts are sometimes vacated because of ineffective assistance of
Why don't you
counsel.
write your argument, because yes, we know that as well.
Well-
What do you think was, what went wrong here?
What went wrong here is that the only defense to this case was justification. It was discussed by both parties during jury selection. It was discussed by both parties during opening statements.
And it was discussed because it was controversial, right? I mean, the evidence of justification was very limited, if invisible.
Well, Mr. Morris's grand jury testimony, which was read to the jury, where he describes shooting the victim in the leg in self-defense after seeing a knife-like object in the victim's hand. The victim was found with a flashlight and with a cell phone. And while he's looking in the cars, those both could have been seen as a weapon to Mr. Morris. And I would also note that when the victim did testify at jury trial, he was mistaken or lying. He was wrong. He said he had nothing on him, but he had a flashlight and he had a cell phone. And Mr. Morris provided himself with grossly ineffective counsel by inexplicably telling the judge that he did not want a justification charge.
So with regard to the searching inquiry, do you agree that it was done or not done?
It was done, but it consisted of very, very long leading questions, which resulted in Mr. Morris simply saying, "I understand." There was no inquiry as to whether he was on any medication or seeing treatment, and I submit if that had been explored, there might have been more of a conversation, and this could have been a different result. And it's clear that the trial was unfair because there was no strategic reason not to have the justification charge.
Well, didn't the court ask Mr. Morris if he ever received any treatment for a mental illness? His response was no. And if he had received treatment for a physical condition that had an effect on his ability to understand, and again, he answered no.
That's correct.
So should the judge have gone then further on and asking some other questions?
I think if the judge had gone further asking about medication, that they would have gotten there. I mean, we all know from being in court every day and being in trials that defendants often are less than forthcoming. And that the longer the inquiry goes and the more conversation, information is drawn out of a defendant.
But is there an obligation to go that far? That's the question, and we'll look at that very carefully. Do you have any other arguments?
I would also note, as I discussed in my brief, the people arguing selective silence by Mr. Morris, and I submit that that was improper. Mr. Hillary did cite a case that might have tempered that a little bit, but the point is that there was no objection. If there had been an objection, and even if the court went the people's way, there would have, at the very least, been curative instructions, and those arguments would have stopped. It would have had less of an impact on the jury.
Okay, anything further?
Nope, that's it.
Thank you.
Thank you very much.
Mr. Hillary, I'm assuming you're going to say that certainly there was the inquiry into whether or not Mr. Morris could proceed pro se was adequate.
Yes, there was, Judge, and not just any inquiry, but one that followed the model colloquy on the matter. I would note also, the people do not blame Mr. Morris for the choice that he made to proceed pro se. We simply expect that, having been shown competent, having been shown to have sufficient understanding of the matters before him, that he's responsible for the choices that he made. And in this case, one of those choices perhaps put him at a serious disadvantage in terms of his own ability to defend. As to the justification charge, Your Honors, I would say that there was just no reasonable view of the evidence to support it. So even if we can argue the defendant maybe should have pursued that, it would have been a losing tactic in the end. So unless the court has any questions, I'll rest on the brief.
Thank you.
Thank you.
639, People versus Curtis Malcolm. One sec, we gotta get Mr. Punch up. There he is, thank you. Go ahead.
Good morning, Your Honors. May it please the Court, Susan Hutchison on behalf of the appellant, Curtis Malcolm. Here, all of the experts agreed that Curtis was a great candidate for YO adjudication.
Okay, I think you have to address something else first. I mean, we don't get there if we don't find the waiver to have been invalid in some manner. So I think you need to talk to us about that first.
Yes, Your Honor. The waiver here was clearly invalid for several reasons. First, being cognizant of Curtis's developmental disability and his IQ of 70, the colloquy was extremely confusing, where the court advised him that the case was basically at an end. He was advised that he could file an appeal, but given the very confusing answer that Curtis replied with when asked if he was freely waiving his right to appeal, he said, no, yes, yes, I'm guilty. And the court did not do any further inquiry.
Counsel, aren't those two issues, whether the colloquy is adequate and whether or not he understood the colloquy, right? Whether his IQ was so low, isn't that maybe something for a 440 motion?
Your Honor, respectfully, I think that this record shows that Curtis would have been capable of understanding what an appeal waiver encompassed if it had been explained clearly and carefully to him.
This is an appeal waiver. It's exactly the same as we have upheld before.
Your Honor, respectfully, I think here, given the monosyllable answers that Curtis replied to, the confusing written waiver, where the written waiver clearly stated that he was giving up all rights to have a court review anything at any time thereafter, and then the contradictory paragraph 7, and the court did not even question him about his understanding of the written waiver, which could have saved the inadequate oral waiver. So I think given the totality of the circumstances, the appeal waiver, the colloquy, was absolutely inadequate, and especially given that the court should have taken a step back, given Curtis's very confusing response of no, yes, yes, I'm guilty. So was he freely waiving his right to appeal, or was he?
We'll look at that very carefully.
Thank you, Your Honor. And turning to the youthful offender adjudication, here Tara Evans basically described Curtis as the ideal candidate. Notwithstanding the serious nature of this offense, there are substantial mitigating circumstances here in terms of that he was not the instigator, he was not a hardened criminal, that this was a crime with an unfortunate series of events that a 16-year-old brain would be not able to properly apprehend the risk. And that's exactly why youthful offender adjudication has been given to these immature brains and to these individuals who should be given a second chance. And Curtis, I mean, the reports in terms of his chances for rehabilitation, Berkshire had nothing but glowing comments about his participation, how he biked for miles to get to the group, how he participated, and how they were very hopeful that he could lead a fully productive life. And he wants to join the Marines. And it just seems to me, Your Honors, that no adult stood up for Curtis in his very short life. He was sexually abused. His mother was drug addicted. He slept on a park bench. And I would ask this court, in the interest of justice and in the interest of the youthful offender statute, to give him that second chance and to not have a criminal conviction follow this young man who has every opportunity for rehabilitation and to be a productive member of the society.
Thank you.
Thank you.
640.
No.
Oh, Mr. Punch, I'm sorry, you're right there in front of me.
Your Honor, I don't have too much to say anyway. Just as I argued in my brief, the appeal waiver was valid in this case. The court did not make it seem like it was a complete bar. He explained it in everyday words that anyone would understand, and the defendant repeatedly just confirmed that he did understand. And then I don't believe that the nature of this crime requires a finding of youthful offender. As I argued in my brief, I could go into it if the court wanted.
Thank you very much.
Thank you.
I didn't mean to ignore you.
No problem.
640, People versus Dwight Bond. Thank you. Go ahead, Mr. Osler. You're by yourself.
I am, Your Honors, and obviously in light of my opponent's submission, I'm happy to rest on my papers, but I figured I'd offer my response to any questions if there are any.
Any questions? Thank you very much.
Thank you.
641, People versus Alexander Whitehill Rideout. Okay, go ahead.
Morning, Your Honors, and may it please the court, Peter Banishak for Alex Rideout. The evidence at this trial failed to prove beyond a reasonable doubt that Alex tampered with physical evidence either at 135 New Wickham Drive or at Mendon Ponds Park. As to count 2, the New Wickham Drive allegations, our basic argument is that it is simply impossible to draw a conclusion beyond a reasonable doubt regarding what Alex did and when he did it. Because it is impossible to draw that conclusion, he cannot be convicted of a specific crime unless the fact finder engages in some level of speculation. We have the glove that was found at New Wickham Drive coupled with the clothing items that were found in the Chrysler at Mendon Ponds Park. However, those things do not allow us to say whether Alex somehow participated in the homicide, which the jury found that he did not.
They found that he did not participate in the homicide, correct?
They certainly did, Judge, but my point is that we don't know based on that evidence whether he participated in the homicide, whether he engaged in some sort of cleanup effort after the homicide, whether he merely attempted to engage in a cleanup effort, whether he perhaps engaged in some conduct in Yates County, or whether he did nothing at all and is not guilty of any criminal conduct whatsoever. I think at best, the jury can reach a conclusion that he must have done something, but that respectfully is insufficient to conclude beyond a reasonable doubt that he committed a crime.
We'll look at that very carefully.
As to count 4, the allegations with respect to Mendon Ponds Park, the allegations are similar, except that we also have Mr. Rideout's interaction with police. Again, there were no admissions made by Alex at that time. Nobody saw him do anything at the parking lot. Nobody even saw him exit the Chrysler. There's no conduct whatsoever aside from his interaction with police, but none of his statements to police were made in furtherance of an attempt to suppress evidence. By the time he spoke to police, Colin Rideout was already done with disposing of a garbage bag in the Devil's Bathtub, had arrived back at the car, and was speaking with police at the back of the Chrysler. The crime was completed, and so even assuming that Alex's evasive or false statements to the police were in some way culpable, at best they constituted hindering prosecution and not tampering with physical evidence, the crime that was charged.
Thank you. We will look at that carefully.
Thank you, Judge. And then with respect to the second point in our brief, with respect to the bill of particulars, Alex simply was not given sufficient notice of the charges against him, which hampered defense counsel's ability to defend against the allegation. Even at the time of sentencing, defense counsel still did not know what acts Alex was charged with committing and what acts he was found guilty of committing. We simply don't know. And as we point out in our brief, an additional problem with the allegations in this case are that we don't know whether tampering with the same piece or pieces of evidence was charged in both counts. And so it is impossible to tell whether these 2 counts of conviction are actually multiplicitous. If this was merely an ongoing effort at tampering, then this was a single.
Was that preserved?
Judge, yes, insofar as defense counsel made a request for additional information, we're not saying that these counts are multiplicitous because, frankly, I can't tell, and I don't think anyone else can tell. But the point is that it's an additional reason why additional information and specifics were necessary in this case to give the defense adequate notice of the charges. And so for those reasons and the additional reasons in our brief, we would ask this court to reverse and grant a new trial for the reasons in point 2.
Thank you. Mr. McCarthy.
Thank you. Good morning, Your Honors. Marty McCarthy for the people. I'm going to start with point 2. That issue is not preserved. Initially, the defendant served a demand for a bill of particulars. People complied. Then in the defendant's omnibus motion, rather than say that the bill of particulars provided was insufficient, they simply asked for another bill of particulars, to which the people responded, we already provided particulars. And then when you look at the motion, in essence, attacking the sufficiency of the bill of particulars, when you read that motion is actually directed mostly to count 1, which is the homicide count for which he was acquitted. It simply says in one paragraph, it incorporates these arguments with respect to counts 2 and 4. However, those arguments are not the arguments that they're making on appeal. The arguments that they made below regarding the sufficiency of the bill of particulars are not the same. So it's not preserved. Moving back to point 1, when we talk about legal sufficiency, you're not talking about proof beyond reasonable doubt. You're talking about light most favorable to the people. whether the crimes were committed, not proof beyond a reasonable doubt. The juries and you are allowed to make inferences, logical inferences, and you're also allowed to look at the community of purpose that all the defendants shared. This isn't just about what happened in the basement, it's about what happened before, what happened at the Walmarts beforehand. It's about what happens afterwards when they drive the body out to Yates County and dispose of it there. And it's about what happens for Alex Rideout at the end when he's found at the Devil's Bathtub. He is there with his brother, and they have evidence from that homicide scene in their car. Colin has disposed of that evidence, and the jury was certainly allowed to infer that Alex was serving as an accomplice to that disposal of the evidence, given the fact that not only were they disposing of evidence of criminality that had other people's evidence, which was his mother's and Colin's, but Alex Rideout had evidence, his own evidence of criminality. His DNA was found in materials both found in the basement and in the garbage bags as well. So the jury was allowed to make that inference, and the people submit that there was legally sufficient evidence, and the verdict here was not against the weight of the evidence. If there are no other questions, I do need to apologize. I had my back turned when the door knocked, and I was standing, and when the door knocked, I sat down instead of standing up, and I apologize. I'm mortified. I don't know if you guys saw it. I am mortified.
We noticed that.
I really apologize.
We were really concerned about that.
It was like the exact opposite of what I normally do. I was standing and I sat, so I am so sorry.
I think we forgive you.
If there are no other questions, I'll rest. Thank you.
642, John Passero versus Jennifer Patsick. Ms. Conley, go ahead. Well, you need to unmute yourself first. No, you're still muted. Still muted. There you go.
All right.
Thank
My
you.
apologies. Thank you. May it please the court, Caitlin Connolly for the father. Your honors, the record does not provide a sound and substantial basis for family court's order prohibiting the children from visiting their father at his home. The allergist's office was aware of the children's asthma. Despite this awareness of both the horse allergy and the asthma, the office's initial recommendation was not to strictly avoid the father's residence. Rather, the allergist's office recommended the children pre-treat with medication and inhalers prior to going to their father's home. The medical advice of pre-treatment changed to strict avoidance only after the allergist was given information by the mother relating to the severity of the children's symptoms that was established to be false at trial. That is, the children did not, as the mother informed the allergist, go to the emergency room after visiting their father at his home.
Right.
The allergist,
The exposure to the horses came after that visit to the emergency, right?
correct, Your Honor. With respect to the oldest son, he did not go to either urgent care or the emergency room. And with respect to the second son, he went to urgent care for what appears to have been a viral illness prior to visiting the father at his house.
Okay, so the basis of the doctor's report then, you're saying was false, and therefore we shouldn't give it any credence.
Correct, Your Honor. My position is that the appropriate treatment plan is the initial plan set out by the allergist's office, pre-treatment and inhalers, which was made with full knowledge of the asthma and the allergy, but was made prior to the receipt of this false information regarding emergency room visits.
Okay, I think we understand that argument. Do you have anything further?
No, that's all. Thank you, Your Honors.
Thank you.
Thank you.
Mr. Hennessy?
Yes, good morning, Your Honors.
Do we have that timeline wrong?
No, you don't. But I would add that the court did not really consider the testimony of the mother or the father. The referee didn't give it that much weight.
So she gave the weight to the doctor's report.
Yes.
That, counsel says is based on some misinformation, certainly on the continuum, the timeline. They were not at the emergency room.
No, they weren't. That doesn't matter, Your Honor, though, because they both tested moderate and severe for horse allergens.
Okay, but we knew that before.
Yeah.
Okay, and I think the doctor's notes seem to be concerned about the symptomology that came about what he thought was right away after an exposure when that wasn't the case.
Yes, that's true, Your Honor, but they still have severe allergies to horse dander, okay? They also have severe asthma. So logically speaking and medically speaking, their exposure to this could put them in jeopardy for an asthma attack, which would damage their lungs. The court looked at all the testimony and weighed the doctor's testimony heavily, discounted what the mother had to say about any emergency room visits or visits to Medicare, whatever that is. It strictly considered the testimony of the doctor, and looking at the testimony of the doctor, he said they had severe allergies, they could get very sick by horse dander, they should implement strict avoidance. It's
Counsel,
not, yes.
I'm sorry, but how should we take the home visit where there was, no evidence of horse dander, any issues with the horses inside the home, and there was a strict protocol?
The court did not credit that testimony.
Well, I understand that.
So we shouldn't. I mean, what we're trying to do is usurp the court in the weight arguments in the weight that it gave the testimony. There's a sound and substantial basis for finding what the court found, which is strict avoidance of the father's house based on the doctor's recommendations.
But the doctor didn't make that recommendation, strict avoidance, until after he believed that there was, an incident that required an emergency room visit. And we know now that that is not true.
We know that's not true, but the court did not consider that when it made its decision. It strictly said that they are not considering the mother's testimony as far as the visit
And
goes.
you've made that clear. We'll have to
Yes,
look at
and if you look at it, Your Honors, this court's not in a position to analyze the testimony. The referee was. The doctor said they had severe allergies. Why would we put the children at risk for
Okay,
putting
Again,
them?
you said that repeatedly.
Thank you, Your Honor.
Thank you.
Good morning. May it please the court, Jason Caffarello, attorney for the children. We've already heard, but the trial court did weigh the credibility and the character of the mother and father and found that it was the doctor, the allergist, that was the best person to testify with regards to the children's allergies. What it looks like, Your Honors, is that it looks like that the parents were trying to manipulate the doctor while the hearing was pending. Testimony had already begun. Dad calls the doctor, then mom calls the doctor. In the end, it looks like the doctor said the only way to prevent an issue with the children is strict avoidance. The only way. That's in their best interest. Because with their asthma and an exposure to allergen, it would cause chronic lung problems. And so I think we see a position, and even Dr. Rockoff testified that he did make a mistake in not reviewing the other doctor's notes before he made the recommendation to the father. The doctor made a mistake in that instance. But just like the court couldn't value the testimony of the mother and father as uncredible, it seems that the doctor did the same. In the end, the doctor said strict avoidance to protect them. Now, what we do see is the children were tested, they were given their skin test, and the boys had a moderate and a severe allergy to horse allergen in May and June of that year. Later in that year, the father is renting a place, and he was boarding a horse with his fiance at a different location, but the children did go visit that horse, and there is testimony that had occurred. And there's testimony that the mother had noticed that there were issues after that exposure. Even afterwards, knowing that the children had severe allergies, the father buys an 18-horse, a farm that can board up to 18 horses. The only way to keep these children safe, Your Honors, is to allow strict avoidance. It doesn't mean that
Let me ask you this question, counsel. You said the children visited the horse, okay? And then later the father bought a horse farm, okay? Aren't those two very different things? you visit a horse, you're playing with the horse, you're touching the horse, you visit a horse farm where the barn is yay far away from the house, and there's many protections that we see in the home stuff. They take the clothes off when they, that are near the horse once they get outside the barn. And, and then there's a long distance in between, and there's showering and all that stuff.
Great question, Judge. I believe the number was 75 yards between the
Right.
horses and the house.
That's better than yay long, yay, yes. Gotcha.
A little more specific.
Yeah, a little more specific, yay.
Judge, the problem is it takes dad to be perfect, dad's fiance to be perfect, the other children that are in that household to be perfect, or other animals. It's the issue is the dander. So if the dander is brought in.
What do the children want?
I met with my clients, Your Honor, and my clients are opposing the relief requested in the appeal. I do understand it is my brief. I know it's not before the court, but there's currently a temporary order that suspends access with the exception of only therapeutic access between the father and a counselor.
Okay, so that's important that we know that information. And we really need you, all of you, to have told us that.
That's in my brief, Your Honor.
Okay. And so that's subsequent to this order.
That is.
Okay.
It's pending. It's currently pending.
And it was based on some new information? Okay.
Correct.
And there's a temporary order. How far along is that case?
There is no, I'm not the attorney for the children in that matter. I did speak with the current attorney for the child this morning. He emailed me with an update. There is continuing therapeutic access for the father, and they ordered a custodial evaluation through Dr. Nathanson.
So we're obviously talking about different issues than allergies.
Correct.
Okay.
Thank you.
Thank you.
643, Benjamin K. versus Karen Hall. Oh, Justice Del Conte is recused, apparently. Okay, go ahead. Mr. K. Can you hear us, Mr. K?
Yes, I can hear you. Can you guys hear me?
Yes, we can.
Thank you, Your Honor. So in this is a child support case, and in this case, the magistrate made a couple of different errors. In my situation, I am a permanently disabled combat veteran. I served in Iraq in 2003, and the VA awarded me what is called the status of unemployability. And
we're aware of all that.
Okay, well, with that, the magistrate imputed income by assessing that I could work full-time on top of that. But the assessment of any additional income would also result in the elimination of the VA disability rating, because the VA does not allow you to receive individual unemployability and work. So it is not possible.
I don't believe there was any evidence at the hearing to support that contention. I mean, there's a supposition that's possible. There was no evidence that was presented at the hearing which would demonstrate your contention that you'd lose some of your benefits.
That's because it was never requested to have income imputed at the hearing. I mean, I couldn't make that argument until the question was presented, which was well after the hearing, and that was presented.
You're looking for a modification. You're looking to reduce your obligation of $600 per a week per child or per month, right?
Yes.
All right. So in that instance, you're looking for income to be part of the hearing.
Yes, but you can't use both incomes. You can't use the VA disability and income from working, which was imputed.
Well, again, you didn't give any evidence that that's the situation or that's the case. Go on.
It was never
Go on.
questioned. I mean, that was never questioned during.
That was your obligation to prove that. It wasn't the court's obligation to question that. But go ahead.
And then the other question is the fact that
Let me ask you a separate question concerning your VA disability. Now, there was no medical evidence with respect to that either. I think, again, I understand your service and I appreciate that, but this is all self-reporting, was it not?
No, that's not accurate. The psychological evaluation is self-reporting. When I sit down with the psychologist, he's assessing my psychological aspect of it. And that was a false statement that was made by the respondent, was that she said that the VA decision was solely based upon self-reporting. No, the medical portion of it, or the psychological portion, is based on self-reporting. There are multiple other factors that are based on military records and events from the war to show that, yes, I was over there. I was in combat. I did have team members who were, one who was shot in the back of the head directly in front of me. And the totality of all those things go into creating the VA disability rating. But just the psychological evaluation is based on your self-reporting your symptoms.
Okay, I think we understand that. Do you have anything further?
Yes, the other one is that the magistrate failed. Well, the magistrate failed to impute income to Ms. K, who stated she's only working 8 hours a week. She was working 8 hours a week and said that she couldn't work more because her daughter has doctor's appointments, but she did not provide any evidence to show that.
It's more than doctor's appointments, isn't it? I mean, she's caring for a sick child with a disease that requires care. I mean, so it's not just.
That's not accurate at all.
She has epilepsy, she can't drive, so who drives her to her appointments?
Well, she's 21, she can get a ride. She doesn't even live with the defendant or the respondent. She has her own apartment, lives on her own. And
well, her income has been fairly consistent for the last 3 years, a period of 3 years, I'm sorry, $24,000 in 2020, $20,000 in 21, $32,000 in 22. So it's been fairly consistent. And your income was $150,000 6 months before your divorce. You were working. You were gainfully employed. You have a degree in mechanical engineering.
Yes, Ms. K has a bachelor's degree as well.
Well, you're the one who's looking for modification.
Yes, but I continued to work for 2.5 years after the filing of divorce. And Ms. K even says or Ms. Hall in her response, that her whole reason for not working is that it's hard. It would be physically hard to work 40 hours in 1 week. That it's a physically taxing job. She says she's not working because she doesn't want to, because it's hard.
Okay, we'll look at that. Anything further?
Yes, the other issue was
that your time is almost up, so you should be wrapping up.
Now, doesn't your Curtis lives with you now, right?
Yes.
Okay. All right.
I have nothing additional.
Okay. Thank you.
Good morning, Your Honors. I'm Karen Hall, representing myself. I really just came so that if you had questions to ask, but I wanted to respond to some of the things that Mr. K just stated. He stated that Brittany K is not living with me. She moved out after this trial had
Concluded?
I'm sorry.
Concluded?
After I concluded, I still do take her on her doctor's appointments. She has spina bifida, so she uses a wheelchair. She has epilepsy, as you guys already know. So I still do help her with her appointments, despite the fact that she's 21, she cannot drive, which again I know you guys know that.
Well, like Mr. Kay indicated, does she have friends that take her?
She doesn't have very many friends, and I don't know that she has any local that have licenses.
Right, I mean, you take her,
Right.
Is it both your daughters?
Just one daughter, and then I have a son that also lives at home with me.
Now, is that your, is Mr.
It's
Kay?
it's-
is
oh,
Mr.
yes,
Kay
sorry.
the father of your daughter?
Yes.
All right, because he made reference to your daughter, not our daughter.
Right, our daughter, yes.
Okay, all right.
My son Curtis.
It's kind of confusing when you're a parent, it's just not one parent's daughter, or
Right.
one parent's child, it's ours, not her daughter.
Right. I also want to clarify that I do work more than 8 hours a week. My testimony was that there are other things other than hands-on physical hours of massage that you get paid for. There's bookkeeping, there's continuing education. It's all in the court documents, so I won't bore you with the details, but there are other things that go into being a massage therapist when you own your own business. It's not just the hands-on physical, which even at that, I still work more than 8 hours per week, obviously, or I wouldn't be able to make what I make right now. But I just want to clarify that I never stated I only work 8 hours a week. But that, yes, I did state that taking my daughter on doctor's appointments and helping her with things that she might need does impede some of my hours.
Absolutely.
Regularly.
Anything further?
I don't believe so, unless you had questions for me.
No question.
Okay.
Thank you.
Thank you so much, I appreciate it.
644, Timothy Ellis versus City of Niagara Falls.
Good morning, Your Honors. I have only 5 minutes, so I have to be very quick here. The decision by Judge Sedita is without question on page 17 based upon the standard of necessary and incidental or integral, and that he cites is directly from Mosier. Mosier was a case from 1999. 1992. In 1999, the Court of Appeals addresses that exact standard. In addressing the standard, it finds that the task in which the injured employee was engaged must have been performed during the erection, demolition, repair, altering, painting, cleaning, pointing of a building or structure.
Is that Martinez?
Martinez, yes.
Yes, okay.
Oh, did I use it?
You said Mosier.
You said Mosier.
That's why,
I'm sorry.
if you look
That's what I'm looking
confused,
at.
that's why.
There are really only 2 cases in here, and I confused them within the first 30 seconds.
Didn't the Court of Appeals and Martinez reject necessary and integral?
Yeah, and in rejecting it...
That's why I was wondering.
Yeah.
You're arguing Mosier.
In 4 occasions, as it rejects it, it talks about the temporal nature of the work, that it must be happening during the course of it, right?
Counselor, I think we get that point.
Okay.
That the Mosier case is an old case, and the rule might have been overturned. But in your brief, don't you say to Krenchek, and don't you say what the rule is, that whether or not tree removal facilitates the project, isn't that your language on page 21? If the tree removal facilitates an enumerated activity, it falls within the ambit of 240?
It does not. It does. If it says it, Your Honor, it shouldn't. It's quite the opposite. This is all about whether it's phases or whether it's contemporaneous, right?
That's the rule in Krenchek, phasing?
Yeah, well, that's the rule, Your Honor. You have the pre-Martinez, or I'm sorry, yes, the pre-Martinez, and you have the post-Martinez arguments, okay? The only thing that comes out post-Martinez is Pratt. Pratt comes out with the Court of Appeals, with the Court of Appeals talking about the fact that it's contemporaneous. In Pratt, they're talking about it being contemporaneous, and therefore it doesn't matter that it's being done, it's not being done ahead. In this case, what we have is we have an individual who is cutting down trees and removing brush. He's doing nothing else. If nothing else occurred afterwards, Ed and I would even agree that it's not a labor law case, right?
Well, yeah, but the testimony was that he was cutting trees in order for where in the region the bridge was going to go in.
Absolutely, 100%.
These trees were marked by the engineer.
100%. 100%. But it doesn't matter because it was not being done in the same time frame. That's what Martinez says. That's what Martinez stands for. You go to Pratt, the next Court of Appeals case on this issue, and what they're saying is, no, here it's being done contemporaneously. This is a guy who's doing inspections while work is actually being done. In this case, no work is going to be done for months afterwards. That's Martinez. Martinez says this has to be temporal. They have to be going on at the same time. You then come to Ed's argument that, well, it's the same company that's going to do it.
I'm going to ask you not to refer to him as Ed, okay?
Okay, I'm sorry. Mr. Smith,
Thank
we
you.
have a lot of cases together. His argument is that because it was the same company that was going to go on and do this work some 2 or 3 months later.
That couldn't be done unless this was done.
Well, it couldn't be done unless this was done. We all recognize that. So did the Court of Appeal, and it's Martinez. I mean, isn't that always the case with site work?
I don't know.
Didn't the city also agree that this was part of it? It had to be done?
It had to be done. I'm not arguing in any way that the work didn't need to be done for the next phase to begin. But the next phase had not begun.
And your argument is because it's not temporal.
It's not temporal. It's not, well, it's my argument, but it's the direct language of the Court of Appeals. It's not something that I've pulled from the air.
I think we've got that argument. Do you have anything else?
I think that's really the argument that matters here. Because assuming that this is not temporal, that this is not during the time that they're doing it.
I've made that point repeatedly.
Got it. Well, then it becomes not construction being done at the time, and everything else falls like dominoes. In other words, if the 241, 240 sub 1 falls by following Martinez, then you have to go to the 241 sub 6 and say, well, then it's not construction, it's not demolition, it's not excavation. It therefore cannot qualify as a 241 sub 6 claim.
Okay, thank you.
Good morning, if it please the court. I could not disagree with Mr. Adams anymore. I think the record shows, and we provided the court with the contracts, the bid, everything is there, everybody's tested.
The contracts.
Yes.
The same contract, right? That the tree removal and the construction was being performed under.
Correct. It was number one on the contract. These are union construction workers who work for the site contractor, Acadia, who is the general contractor.
Does that matter that it's the same contract?
It helps. Doesn't matter. Maybe not in every case, but certainly in this case, where we're looking at a situation where we have a larger construction project, and in order to do the construction project...
This has to get done first. If this
Got it.
doesn't get done, nothing else gets done.
Precisely, Your Honor. And I don't want to beat the dead horse, but I think the law is clear, even as Your Honor mentioned, the Koenig case from 2020, which came out of this court, had to do with the work being done on the side of the thruway. They were removing trees. In that case, the court found issue of fact because there wasn't enough in the record, but certainly tree removal in that type of construction context falls within the protections of Labor Law 240, as it does in this particular case.
Anything further?
If that's the sole issue, if the court has any other questions with regard to 240, the 241-6 claims, disposal of debris, if not, everything is covered in our brief. If there's any questions, I'm happy to answer.
Thank you.
Thank you.
646, Kornarski versus Van Dyke.
Morning, Your Honors. If it please the court, John Collins on behalf of plaintiffs Kevin and Jennifer Konarski, on whose position on behalf I argue that the trial court erred in denying the Konarski's motion for partial summary judgment on the issue of negligence and proximate cause. The record establishes that Thomas Van Dyke, defendant, was negligent as a matter of law for two related but independent reasons. First, he admittedly failed to see what was there to be seen, acknowledged that he never saw plaintiff's vehicle before changing lanes.
Did your client see that vehicle?
Yes, my client saw the vehicle.
After the accident, or did?
He saw it beforehand. When he got on from Route 400 onto the thruway heading east, he saw Mr. Konarski's vehicle behind him. And then, Mr. Van Dyke's truck, struck the side of, came up from behind, which is where Mr. Konarski first saw him, came up from behind, turned into his lane, and with his front bumper struck.
But didn't your client indicate that he was trying to pass him on the right?
No. Mr. Van Dyke testified and then stated by affidavit that Mr. Konarski, quote, confessed he was passing Mr. Van Dyke on the right. But I submit that the court should disregard that and that defendants should basically be barred, precluded, or stopped from asserting that, because during the discovery phase, plaintiff asked for any and all statements that plaintiff had made, and defendants expressly stated they have no statements from the plaintiff, Mr. Konarski.
What time of day was this again? This was early in the morning?
It was approximately 7 a.m.
Right. There was a question of whether or not your client had their headlights on, wasn't there?
Again, I don't think there is a question.
Wouldn't that be a situation there where then the truck driver wouldn't be able, maybe not able to see your client because it's dark at 7 a.m. and there's no headlights on?
Well,
and it was misty, right?
Two responses to that. It had been raining. Mr. Van Dyke, the defendant, testified the rain had stopped and the roads were drying out. And he said, I never saw the headlights, but he also said I never observed the car. And I cite, two cases indicating that where someone says I never saw the headlights, it basically is, just speculative to say that, they would have observed the car because
Could it be a question of fact, maybe?
Well, I don't think it's a question of fact, but even if it were, this accident occurred, as I said, around 7 a.m. Plaintiffs interposed proof establishing that sunrise had occurred shortly before that, and under Section 375 of the Vehicle and Traffic Law, it requires that you have headlights on only, 1/2 hour after sunset up to 1/2 hour before sunrise. So
You have to have them on during rain, when it's raining though, too, right?
Yeah, but as I said, Mr. Van Dyke said the rain had stopped and the roads were drying out. But regardless of whether there were, headlights on or off, the fact remains that there was enough daylight there to see a vehicle, and Mr. Van Dyke simply turned into that lane without admittedly seeing plaintiff's vehicle. The fact that he struck plaintiff's vehicle right at the area where the driver's door meets the rear passenger door, indicates that certainly plaintiff was right next to him and that he, didn't see him, changed lanes unsafely, and therefore...
Although he didn't get charged with that, did he?
He didn't get charged, but in the police report where it said, factors involved in accident, the investigating trooper stated unsafe lane change, although they have discretion.
We'll look at all this and see if there are questions of fact or not.
Yeah, but even if there are questions of fact as to comparative fault, finally I submit that under Rodriguez v. City of New York, plaintiffs certainly established their entitlement to summary judgment, even if there's a question of fact as to, sole proximate cause or in the alternative, comparative fault. Thank you.
Thank you.
May it please the court, Your Honors, Michael Sullivan on behalf of the defendant respondents. Justice Parker made it clear in his decision that there's just too far many issues of fact in this case that would warrant even partial summary judgment granting. When we talk about the speeds of these, we have two competing versions of the accident, either which will go to a jury, and obviously the jury will weigh the credibility of the witness. What's being argued today and what was argued at the motion is everything is up for the jury determination. The positioning of the vehicles are completely different. The speeds of the vehicles are completely different. Where
The
the
weather is completely
weather is
different.
completely
The lighting
different.
is completely
Headlights,
different.
you got it, Your Honor, exactly. And as it for the statement, I would say, you know, you can meet with clients during the course of discovery, but sometimes you learn things during a deposition that are said. There's no way to be able to prepare for every single possibility of that. But at the end of the day, it was known, he made a statement clear, he was asked a question, he answered it honestly. So that was properly before the court, and I believe these are all credibility issues that the lower court got it right. Now, I would respectfully ask that this court affirm the lower decision. And if there's any questions, I rest on the paper.
Thank you.
Thank you.
647, matter of Local 32, City of Utica. We just have to wait for Mr. McBride just a moment. Sure. There you go.
May it please the court. My name is Kelsey Schaefer, and I represent the appellant, Local 32, the Utica Professional Firefighters Association, in this matter. Today, we'll focus on two arguments. The first, that the arbitrator did not exceed his contractually prescribed power. The second, the arbitrator's findings were rational and well-reasoned. As this court knows, it is very difficult to set aside an arbitration award, and a court may do so only in limited circumstances, as provided by the CPLR. The parties have agreed in their CBA and that the decision of the arbitrator shall be final, conclusive, and binding. In New York public policy has long favored parties' efforts to resolve.
Let me shortcut this just a little bit. I think the standard of review is irrationality. The court below needed to find that the arbitrator's decision was irrational.
Correct.
Okay, and I guess impliedly, because they overturned it, that's what they found.
Correct.
Okay? And so if you could just speak to that, was the arbitrator's decision irrational or a rational and reasonable interpretation of the contract?
Our position is that the arbitrator's decision was rational and was not only rational but well-reasoned. It was based on a variety of factors. The provision itself, which is about emergency leave, it was about
when you have to give notice. That
exactly.
You need that.
But it doesn't exactly specify exactly when you have to give notice.
Right. We all agree that the contract is silent on when the request should be made. It only
So
states.
the arbitrator then had to decide whether it was, during working hours or just before when you're going to be missing work.
Yes, that's correct, Your Honor.
And and they chose one.
Right.
And you're saying that the one they chose wasn't irrational.
Right. It's a very high standard to show that it's irrational. Basically, the standard is that there's no proof whatsoever.
We know.
Oh, yeah. Yes, right. I'm sure. Yeah.
I do think we understand your argument.
Okay.
Do you have anything further?
I don't believe so. The only thing I would note is that the arbitrator had policy reasons why he came to this decision, such that firefighters have long shifts, they're 24 hours.
We understand all that.
Okay. Then the last thing I would just note is that the irony is that the Supreme Court, in modifying this arbitration award, actually added a new provision of the contract, because the Supreme Court's modification now requires the firefighters to show up knowing that there's an active emergency, to show up to duty, possibly leave a hospital or an emergency room, report to duty, and then say, I actually need to leave. And so that problem disadvantages everybody.
We understand that.
And if there's nothing further, we rest on our brief. Thank you.
Mr. McBride?
Good morning, Your Honors. The Fourth Department has, as you well know, has long it's well established that it has to be either irrational or, as this court has said multiple cases we cite in our brief, clearly exceeds a specifically enumerated limitation on the arbitrator's power, which can be set forth in a collective bargaining agreement. This collective bargaining agreement specifically states, his powers are strictly limited to the application and interpretation of specific provisions of the agreement and may not add to, modify, or otherwise deviate from those provisions. Here, the emergency leave provision in the contract was actually amended to add in the phrase, emergency leave can only be granted during a member's tour of duty. He may be released, added the language, may be released from duty, and it requires him to report back to duty when the emergency, subsides. As we, put forth in our papers, it's very clear, it's unambiguous. You can't, you have to be, you're getting released from while you're on duty. You have to report to duty first, and you're required to report back, return to duty. We think it's very clear. This language was added to the contract.
So you're saying if there's an emergency situation, for example, there's a car accident, I'm scheduled to work that day, one of my family members is in the hospital, and I have to go now, I find that out the night before, but still I have to go into work, report, clock in, hey, my family member's been in a car accident, they are now, for example, I'm practicing in Niagara Falls, and the accident occurred in Syracuse. I have to come to Niagara Falls, report to you that there's been an accident. My family member's in the hospital in Syracuse. Can I take emergency leave? I had to get in a car, drive 2 hours, 2.5 hours now to Syracuse after you come in. Is that right? Is that what you're saying?
Well, Judge,
Does that make sense? Is that what you're saying?
That's not. That if you want to take advantage of the emergency leave, because you don't have to pay that back. It's not an accrual, and the city doesn't. The city doesn't require them to pay that back.
But you're saying I can only make that request during my tour.
Yeah, it's for emergencies that occur while you're on duty. This isn't one that occurs. There's other leaves available to you. If that occurs, you could do a man-for-man leave. You can say, hey, someone can cover for me. I had an accident happen.
I don't have that
situation. That always happens. I'm sorry?
In my scenario, that doesn't happen. It's not available.
Yeah, in your scenario, if it happens when you're not on duty, you have other leaves available to you. If you don't, you can attend to that emergency. This is just for emergencies that occur while you're at work. So you get to leave work.
Well, we're going to look at that language very carefully.
Thank you.
Anything further?
No, we'd rest on. If you have any questions, I'd be happy to answer them. Otherwise, we'd rest on our papers.
Thank you.
Thank you.
648 Seneca Meadows, Inc. versus Town of Seneca Falls. Yeah.
It doesn't matter.
Excuse me, I'm just confused. Who's arguing?
Eric.
Okay.
William Reynolds, I'm on the brief, but I don't need to.
Oh, could you just sit in the seat behind, right there? Perfect, thank you.
Good morning. May it please the court, Douglas H. Zamalis for appellants. May a petitioner with no environmental interest or injury bring a claim under SECRA? This court and the Court of Appeals have said no, particularly where, like here, the petitioner's sole interest is economic. And in matter of Schmidt v. City of Buffalo, you held there's a limit on those who may challenge governmental actions under SECRA. And those seeking to raise SECRA challenges must establish both an environmental injury and that the injury falls within the zone of interest to be protected. And in affirming this court, the Court of Appeals recognized in Mobile Oil Corp v. Syracuse IDA that to have standing under SECRA, a party must demonstrate it will suffer an injury that is environmental and not solely economic in nature. And SMI's interest here is solely economic. It starts.
How's the Harzenders case come in play here? Basically, isn't that the case where there was an economic interest and the court said it was so overwhelming that we're going to establish standing?
Yeah, well, that's distinguishable, Your Honor, because Har Enterprises properties were targeted for rezoning after it proposed a supermarket, and it was changed to residential. With Mobil Oil Corp., Mobil's property was actually part of...
Didn't Harzenter also, they allege an eventual environmental consequence?
I'm sorry, Your Honor?
They alleged an unspecified eventual environmental consequence, wasn't that? So isn't that within the zone of interest?
In
Harzenter?
In Har, I believe Har, the holding was, the standing was, they had a rebuttable presumption of standing, presumptive standing, because their property was targeted.
Why wouldn't it be presumptive here? I mean, you look at a situation where Seneca Meadows, they're the only one. Obviously, this law has been directed. You cannot, local law 3 says you can't have a dumping area there in the town.
Yeah.
The only dumping area in the town is Seneca Meadows.
Well, it doesn't...
Isn't this targeted at Seneca Meadows then?
Nobody
else that's involved?
Your Honor, no more than Mobil Oil Company's property was targeted by Pyramid when it proposed the Carousel Mall. And the Court of Appeals said Mobil's economic interest there, even though it came under the law, like local law 3 applies to SMI, Mobil lacked standing. So we submit respectfully that these facts are much closer to Mobil Oil Corp. Than Har. And the trial court found that SMI's economic interest was irrelevant, when in fact it's highly relevant because
did SMI produce at the lower proceedings any economic or environmental interest involved here?
Not a single environmental interest before the board or the trial court.
It was all economic, wasn't it?
It's all economic, Your Honor.
We invested all this money in our facility, the roads, all the employment here. There was no discussion, though, where the town is going to take their dumps now, is there? Their garbage?
Well, the issue never came up during the legislative process or the secret review, and it's important, I believe, for the court to understand that local law, the town board didn't pull December 31, 2025 out of thin air. The 2007 host community agreement...
Your permit expires, right?
I'm sorry?
The permit expires at that time, right?
And the permit expires at that time. The state's expert agency on solid waste management had already determined after a secret review that this facility would close in 2025. So we submit that allowing a polluter to use this law to strike down an environmental protection statute just so it can continue to profit at the environment's expense is directly contrary to SECRA's purpose.
We'll look at that very carefully.
Thank you, Your Honor. Even if SMI had standing, SMI's substantive challenge should have failed because the board complied with SECRA and the trial court went way, way beyond its limited review function.
Are you saying that they took a hard look at this, at SECRA?
They did take a hard look at SECRA, Your Honor. They went through the environmental, they considered the action.
Wasn't it just introduced at one night at a meeting by the, what was the council member?
It was board member Lutz.
Lutz, yes.
Who was a duly appointed board member.
She was against SMI. She wanted this closed, right?
She's a legislative elected official. She's entitled to have opinions on what should happen with her town. And the court was bothered that those forms were not prepared by the town.
They weren't. They're prepared by her attorney, right?
They were prepared by her attorney.
You normally have the town attorney. Isn't the town attorney employed to do that?
There's no law saying a secret document has to be prepared by the town attorney.
But wouldn't it seem logical that the town attorney would want to have some input in this?
The town attorney did have input. In fact, he was advising the town board throughout the process, and the trial court quotes him at length, and he was spot on. The town attorney was.
Do you have anything further?
Yeah, I do want to point out one thing briefly. The relevant question here in the SECRA review with respect to solid waste was in the EAF, would there be a substantial increase in solid waste? And restricting where solid waste can't go doesn't create an increase. And the question is, would it create a hazard to human health or environmental resources? And nothing in the board's record ever said it did. The board's neg deck specifically found that the law would not result in a substantial increase and is intended to avoid possible adverse health hazards from waste disposal and wouldn't create the creation of any hazard to human health. So that was asked and answered right in the board's negative declaration. To conclude, the trial court's de novo review is directly at odds with your seminal decision in Holmes almost 50 years ago. And it would raise the secret compliance bar for thousands of state and local agencies that go through this process every work day of the week. The board's negative declaration wasn't irrational, it wasn't arbitrary, and it wasn't capricious. Therefore, it must be upheld. And with that, we'll rest on our brief. Thank you, Your Honor.
Good morning, Your Honors. Eric Ferrante for the respondent, Summit Meadows, Inc. To address the standing issue first, I think the court recognizes, and we cite in our brief, HAR, the existence of HAR. HAR establishes an exception to the zone of interest test that Mr. Zemelis just discussed.
What's a zone of interest? Economic is not a zone of interest.
Well, and that's why HAR sets up an exception to the zone of interest. There is no need to show under HAR if your property and your ability to continue to use your property.
But there's no intent to abandon a zone of interest in HAR.
And exactly, that was actually my next point.
So it's still your requirement to show that this falls within a zone of interest. That's some environmental aspect of this particular project.
Respectfully, Your Honor, the way we view it is the zone of interest remains viable in some contexts. It does not apply in all contexts. And as HAR teaches, and in fact, as the Court of Appeals...
Isn't the situation a little different because, as your opponent indicated, that this is a zoning law that was in HAR that was after they entered into a contract?
Understood.
You know, and obviously it looks like they were targeted.
That is, HAR did address a zoning regulation.
And here's not a zoning regulation.
That is correct.
It's a police power situation, right?
Understood. So there's a couple issues with that. First, HAR does address the zoning regulation, but HAR itself did not say that its holding was specific to zoning regulations. And after HAR has been decided, other courts, including the Second, Third, and this court, have applied HAR outside of the zoning context. There's a case from the Third Department, I believe it's the Third Department, it's Skenesboro Stone. There, the town instituted a townwide ban on mining operations, similar to the townwide ban on waste disposal in this case. The Third Department looked at that and said, there was the petitioner there challenged the law. It was a mining operation, and they said, we can no longer use our property to mine if this law stands, and we have an interest in being able to continue to do that. There was no allegation of economic injury. There was no discussion of the zone of interest test. Instead, the court said, you fall within the ambit of HAR, and HAR applies because you have a legally cognizable interest in being able to continue to use your property and ensure that before you are prevented from doing so, the town complies with the strict requirements of seeker. And that's exactly
Society of Plastic was held after HAR, correct? And that test still is that you establish standing within a zone of interest, protected by seeker.
So there's two lines of cases here. Society of Plastics does apply the zone of interest test. Society of Plastics is similar to the mobile oil
And
case.
HAR did not abandon zone of interest. So zone of interest still applies.
Well, and that's why I say it's an exception. If you look at our brief and Mr. Zemelis' brief, cite the case Gurnett Asphalt, which was a Court of Appeals case in 1996, decided 7 years after HAR was decided. In that case, the court makes clear that HAR sets up an exception to the zone of interest test. There the court says, and I'm going to quote.
That was a zoning case.
That was a case. HAR was a zoning case. In Gurnett Asphalt, the court says, standing to raise a seeker claim involves this variation. A seeker challenger must demonstrate that it will suffer an injury that is environmental and not solely economic in nature. So the reference to environmental gets to the zone of interest.
Your client made no reference at all to an environmental.
Your Honor, the next sentence, though, is significant. The court begins, however, where the challenger to the seeker review undertaken as part of the zoning enactment, the owner of the property that is the subject of rezoning need not allege the likelihood of environmental harm.
Rezone. This is not a zoning case.
Again, so I raise that to note that HAR establishes an exception to the zone of interest. It doesn't do away with it, but in certain instances, it's not applicable. And while HAR was a zoning...
Isn't it an exception? I mean, they did not abandon it, so how is that an exception?
It's an exception because in instances where property is directly targeted, and the classic example is a rezoning situation.
It's not a rezone.
So it's a classic, that's the example, that's where it comes up the most often.
You agree it's a police power.
I agree it's a police power. I do not believe that that's dispositive, and I'll address that in a moment. But the fact that it's an exception is made clear. Gurnett Asphalt says there's the zone of interest test. But in a situation where the property is directly targeted.
Society of Plastic was decided after Har, which says zone of interest is still required.
Society of Plastics, though, was not a case similar to Har. Society of Plastics was a case that involved a local law restricting the use of plastics products.
Right, I'm familiar with it.
First of all, that case did not, it did not hold that the petitioner did not have standing because it failed to assert an injury within the zone of interest. It found lack of standing based on associational standing. But even still, there was no claim there that the petitioner's property could no longer be used as it had been used for decades prior, like there is here, like there was in Har, and like there was in Granite Asphalt. So there's, the point I'm driving at is there are two lines. Under the zone of interest standard, that standard applies where there is a regulation that does not directly target and impact a party's ability to use its property. But whereas here, and as in Har and as in Granite Asphalt, as in Tupper versus City of Syracuse, a decision out of this court, as in the Skenesboro Stone case, where there is a decision that directly impacts a landowner's use of its property, and they can no longer use it, the Har exception applies, and that says you do not need to look at the zone of interest, you don't need to allege any specific environmental harm. If you have an interest that is so significant and that is impacted by that local law, you are the proper party to challenge the town's seeker compliance.
What if they do have standing?
If they have standing, then we get to the merits. And our view here, as we set forth in our brief, is that the trial court correctly held that there was not a hard look taken here. The question is not, did the board look at and consider those areas of environmental concern that they did identify, but instead, did they look at the actual environmental impacts that they were required to take a hard look at? And the answer to that question is no. They never considered the consequences of requiring the SMI landfill to close and what impacts would be associated with those. Maybe there would be none. Maybe they would not be significant. That's not a question for the court to decide. And it's not a question that the trial court decided. The question is, did they even consider those? They have discretion to reach a conclusion once they consider those, but they have to consider them. And they failed to consider those impacts. And they'll say, and Mr. Zemelis, I think, made reference to this, that and the court did as well, well, did SMI ever raise those beforehand? And two responses to that. First, seeker puts the obligation on the lead agency, here the town board, to identify the relevant areas of environmental concern. They are not entitled to bury their head in the sand and then say, well, nobody told us this was going to be an impact. Particularly where here, it's an obvious, the very purpose of the local law was to require the closure of Seneca Meadows landfill. To not then take the step and say, what are the consequences of that very purpose, that very obvious and necessary outcome of the local law, fails to consider the environmental impacts that may or will arise as a result of the closure of the landfill.
I think we have that. Anything further?
So just one point, returning to the standing issue, the one point I'll note, I know there's some concern about the zoning issue. So in Society of Plastics, the Court of Appeals explained, make sure I quote this correctly, that the better approach is to look to the aim and impact of the action, whether in the form of zoning ordinance, a local law, or other governmental action. And so the purpose, whether it's a zoning ordinance, a police power ordinance, is not dispositive of the question. The court needs to look at what the impact is to determine whether the case falls within the ambit of Har, and we would submit that here it does. So,
thank you.
That's it. Thank you.
649, Snyder versus Oliva? How do you pronounce that? Oliva. Okay, thank you.
May it please the court, Joe Lita for the plaintiff appellant on this matter, Brent Snyder. Your honors, we bring in this case today on appeal. We believe the lower court has erred in awarding payment of maintenance on this matter. If we look at the policy, the court's decision actually brings it up. He says there is a strong policy against recoupment of overpaid support.
Okay, so strong policy. So what's the strong policy here?
The strong policy is that the support has been overpaid. When we look at the policies of the other case decisions, it says that it was necessary to keep the person, to pay their bills.
Okay,
Spent.
and I see nothing in the record that talks about a hardship, that she was in danger of being put on the street, losing her house, feeding herself, any of that stuff.
That's correct. Right now, what's on the record is that there was an award of maintenance that was necessary at the time of the divorce, and as a result, that maintenance was paid.
Necessary is an interesting word, okay? I would have said that it was contractually obligated. I mean, they made an agreement to pay this award.
That's correct.
And they made an agreement in the judgment of divorce, in the property settlement agreement, as to what the amount is going to be and exactly how long it was going to be.
That's correct.
Right. So, so I'm trying to figure out where the public policy comes in, of allowing people to keep amounts of money in excess of what they agreed to, because for some reason a third party decided that they weren't going to honor that.
Well, let's not forget too, that third party decided that 2 years after it was discovered. So there's an issue of latches there as well that we bring up in our papers. But again, yeah, there is a policy in place, right? And this is something that's been long-standing by the courts for both maintenance and support payments.
And there was no support payments here. There's no children.
No, correct.
Okay.
But I'm just saying that this is a policy that the courts have made prior decisions on in the Kelly case, and it's not binding on this court, but the Biddle case clearly sets forth in our papers what that policy is. And basically the idea is that that money has been spent. It's already been accounted for. He's paid it out every month. If he cared, he should have noticed that it stopped.
Counselor, and I think part of your argument here is husband didn't make any attempt to notify wife, stop making those payments, or stop taking those payments, or return them to me, or hold them, or anything like that. There's nothing in the record that there was any communication from him to her that she was being overpaid.
Correct, not until 2 years afterwards.
Right.
And that's when they immediately filed the motion. She didn't even know about that before the motion. As soon as we get the motion, we stipulated to stop the payments.
Based on this record, her knowledge is de facto that she entered into the separation agreement, and then we have a judgment, and then we have an order directing Ford to make those payments.
That's correct, Your Honor. That is correct.
But isn't that knowledge on her part that the payments were limited to 20 months?
Just as it was the knowledge on his part. His client's part.
But wasn't it on her part as well?
Correct. I think they both had knowledge. I think they're both in the same situation, so the question is, who bears the burden here?
So he wasn't writing you checks every month. Some third party was taking the money and delivering it to your client. So it's not voluntary. He didn't pay that money voluntarily. And I don't see that the passage of time makes it any more or less voluntary than at the outset.
No, but then there's the issue of latches that comes up, right? If both parties are assumed to have knowledge of what's in the agreement, waiting 2 years and gathering $30,000 almost of arrears, that's pretty substantial and prejudicial for a client that, I forget what my client's income was, but I believe it's below 50. So, I mean, that's a hell of a burden that is being put on my client as a result of someone's overpayments. And then when he tries to stop it, they keep paying it. Right?
I think we understand.
Did she keep taking those checks then afterwards?
No, she didn't know until the order to show cause was served at her.
Ford kept paying her afterwards. Ford was waiting for a separate order, right? The order to
No.
show cause stopped everything.
We got served with the order to show cause immediately we stipulate. Like right as we get served with it. I stipulate immediately. I call up RJ, Mr. Friedman, and, pardon me, and...
You're casual, Mr. Lita.
We've spent a lot of time together.
I know, but still. Right?
I apologize. That wasn't on purpose, but if there's any other questions.
Thank you.
Thank you.
Good morning. May it please the court. RJ Friedman on behalf of the respondent, Brandon Holova.
So let me, I'm sorry, but I have to ask, there's nothing in the record that you or your client notified the ex-wife, don't take those payments, hold those payments, we want them back. There's nothing in the record indicating any notice on the part of your client or you to her, right? Correct?
I think that's accurate, Your Honor. Yes. I do not believe that the parties had little to any communication after their divorce. They did not have children in common. And I believe that we had to actually figure out where Ms. Snyder was living at the time that we brought this action. But is in the record.
Why doesn't latches apply?
Well, Your Honor, latches doesn't apply because, first of all, we're talking about $28,000 cumulatively over 2 years. So each month adds $1,200 to the mix, right? So it's not like it was $28,000 paid 2 years ago. It's $1,200 a month that gets paid over 2 years, where my client's efforts to contact his employer and say, hey, I'm done, Ford continues to be ignored. So he had to retain counsel. He had to apply for a TRO. That's actually what stopped the payments from being made to Ms. Snyder, because finally there was an order submitted to Ford to that fact. At no point did Ms. Snyder give back the payments. At no point did she offer to return them. She kept them. She continues to keep them.
Those payments were not voluntary, were they?
They were not. As the record shows, there's an income withholding order signed by the divorce judge that directs Ford to pay for 20 months.
For the benefit of Ms. Snyder?
Completely for her benefit. And I don't, honestly, Your Honor, I don't believe that she didn't know that the $1,200 a month checks keep coming and she's not entitled to that. That's not in the record either. All right, she gets $1,200 a month. She continues to cash those checks. She continues to pay those checks improperly because there's no valid court order in place at that time. And I think that's where the public policy argument falls short, okay? The public policy behind the overpayment or recoupment of child support and spousal maintenance focuses on valid, enforceable, current orders of support.
We're only talking about maintenance. We're not talking about child support.
Agreed, but there's a lot of discussion about this public policy for both.
Right, I mean, in situations where there's child support, public policy argument is more valid.
It's clear cut. It's detrimental to the children,
Sure.
right? But here we have a court order that was completely done, and the payments keep coming. There's no public policy to support keeping money that's not yours, and that's really what happened here. Is that the payments keep coming, and the public policy doesn't apply to that. Quite frankly, the public policy doesn't apply here. Here we have arguably a simple case of unjust enrichment, where a party received money that was enriched by that money, $28,000. It was at her ex-husband's expense. And now we ask the court to say, well, it's not fair. It's against equity and good conscience that someone should keep $28,000 of someone else's money.
Especially if they agreed to a certain thing and now that certain thing has changed.
It's a very specific contract, right, Your Honor? It is. It's a contract that...
We understand that.
Right. So I think the court has an opportunity here, though, Your Honor, to make it clear that there exists a duty from support payees to return money that is not theirs, when it's very clear that their support order has ended. It's something that comes up often in cases where support orders end and support payments continue by some sort of third party. The court can take a position here that says that that has to end, that there needs to be some
I think it's
sort of
limited
duty.
to a situation maybe where there's maintenance.
Maintenance and or child support, if it ends, yes.
I don't know about child
Not
support.
about-
But specifically in maintenance, if you receive maintenance past your term, I think there should be a duty to return that. That is lacking in case law, Your Honor, otherwise we'd be citing it here.
You've made that clear. Thank you.
I have nothing else, thank you.
650 Trousseau versus Brev 519 LLC, and Justice Hannah is recused on this matter. Just a minute. Oh, there. There he is. Okay, go ahead.
Good morning, Your Honors. My name is Jeff Turpak. I'm the attorney for the appellant here, Brev 519 LLC. And may it please the court. We have a situation where the way that the trial court has ruled here is sort of putting our client in a position, and anybody in a position, where they have to overly investigate every single property that they would ever purchase, because there's no physical evidence or title evidence that an easement existed prior to the court.
They'd almost have
granting.
to interview the neighbors before they buy and sell a property.
Yes, exactly. They'd have to talk to the neighbors. They'd have to investigate not just their survey, but probably other people's surveys and searches as well, in order to figure that out. This is not a situation where, like some of the case law we referenced, where there was even an easement on somebody else's title search. There's none. So this is an easement by necessity that's being declared in a situation where there was no way to discover that on title, and physically it would be very difficult to discover that. Given the nature of the property we're talking about, this is behind a bunch of apartment buildings. It was an unimproved lot. Maybe it's cement or gravel, but nothing indicating that there was some sort of dirt road or driveway or something like you would imagine on a country lot when you see an easement by necessity.
And this is a summary judgment motion, correct?
Yes, this was on a summary judgment motion.
Suggesting there are issues of fact here so that we cannot go ahead and go along with this. That's what you're trying to say?
Yes, yeah.
Okay.
So between that, my client has a driveway, right? That's what they're trying to get the easement over, but, everyone has a driveway. You would then have to check everybody's property behind your property to make sure that they're not using that driveway. And unlike some city lots, certainly in Buffalo and in other cities where it's obvious that maybe a driveway is shared because it splits off to another garage or anything, there's no improvements on the land behind us. And in fact, the parcel, the tiny lot, as we call it in the brief, that we're talking about, wasn't broken off of my client's lot. It was broken off of a separate lot altogether back in, I think, around 1989. So it's basically the backyard of somebody else's lot, and it matches the backyard of the lot yet to the south of it, in the sense that they're apartment buildings on the front, backyards in the back. But in order to go investigate all of that would be a lot of work.
I think you've made that point.
Okay. And just on the other point that I'd just like to touch on, or I guess they both go together, but in terms of unity of title, I know I've said this a little bit, but we're in a situation where typically when unity of title, both parcels are on one deed at one point, and they usually share a legal description, a survey, et cetera, et cetera. Now,
that's not mandatory.
It's not, but in the case that we cite, the Times Square properties case, they do talk about how you need to treat the properties similarly. Treat the properties again as the same, not just I own two properties next to each other.
Are you saying there was no unity here?
We're saying yes, there's no unity. That was what the trial court asked for more evidence on, and then decided that there was, but we're still arguing.
No unity here. Jason had unity in title.
Mr. Jason did, but then when he deeded the properties out, there were multiple deeds with accidents. I mean, he over-deeded the property off to Trousseau. I mean, this is a situation where
You didn't over-deed it, Jerome.
There was a second deed put on which he deeded property out that he no longer owned.
You gave him a quitclaim deed.
Yeah,
I'm giving you what I got.
Yeah.
And all he had left was a tiny lot.
But within those deeds, the legal descriptions were separate. What was once all 18 St. Louis, which included the tiny lot at the time, was in a separate legal description within the same deed as 519's property, the 519 Virginia place. So there were two separate legal descriptions.
He didn't over-deed that.
But then later, when he deeded it out, he had already sold 18 St. Louis as we know it today.
A quitclaim deed says, I'm giving you what I got. If I don't have anything, that's
then he's unable to give any more.
And all he had left was a tiny lot.
Yeah.
So is it the best way to transfer the property? Probably no, but did it accomplish that? Sure it did.
No, and we're not arguing that deed was null or insufficient. If you overdeed, you can only give what you have. The argument there, though, is that we never really got into it, or the court never really got into it in this, but the intentionality behind the easement by necessity is also there, and it's tough for us to say because we are 5 buyers or more down the line.
I think we have.
Understood. All right. If there's no other questions, I'll rest on my brief.
Thank you. Mr. Beck?
Good morning. May it please the court. I'm here on behalf of Anthony Taruso, the plaintiff in this action and the owner of the so-called tiny lot. From our perspective, this case boils down to a scenario where the defendant had acquired the surrounding properties and wants to keep control of this piece of property for its tenants to park. Is very clear on his survey that he wasn't acquiring this property, very clear on tax maps that he wasn't acquiring this property, and very clear that it was being used for parking. My client owns another property at 421 Franklin Street. And, as we all know, and it snows in Buffalo, it's important for him to have off-street parking for the tenants at 421 Franklin Street, and as a result, retain this property.
So counsel, you're saying that the easement by necessity would support a another property that is not appurtenant to the dominant estate?
It is the only way that he can beneficially use this property.
Well, yeah, but that's not in the record. That's not in the record.
I disagree. I think he's conveyed in his affidavits that the only use that he could use of the property is for him to come on and park, or I think he references his significant other, which is the occupant of 421 Franklin Street. 421 Franklin Street is Sue Ann Simone Court Reporting Services. That is his significant other. They utilize that property for off-street parking as well.
Don't you have access from the Franklin Street property then?
We don't, Your Honor. If you
So
go to
they
the
border
west,
on it.
I'm sorry?
They border on it, you said?
If you go to the west, there's a fence and a building. If we go to the east, there's a building. If we go to the south, we'd have to go over a foundation that exists. It does not allow us to pass over. In any direction to the south, we have to proceed over the top of the remnants of an old foundation in order to move in that direction. And we'd actually have to go across multiple properties and then get into a parking area. And then, so we'd have to go through multiple pieces of property in order to get to an alternative highway. This is the way that we've done it for literally 20 years. We're using it in the same fashion in which the 519 Brev uses it. Simply as a driveway. Okay,
I think we have that argument.
Okay, from the moment we came on, they proceeded to block our access. First by putting a dumpster on there, then by removing survey
We
stakes.
understand all that as well.
Okay.
Anything further?
No, I would convey that, there was
I
clearly.
have one question, okay? There was a time that you could have reserved that particular piece of property for yourselves. Your client could have reserved it for himself. Is there any evidence in the record that he ever did that? I didn't see any.
It would have been nice if he thought to reserve an easement. He didn't, in fairness.
Okay.
So he's in this
Thank you.
scenario where it's an easement by necessity. The only way he can beneficially use the property is by accessing it via 519 property, 519 Brev.
So there's still like an issue of fact here. Could be.
I don't know that there is. I believe that
It's a summary judgment motion, right?
Right, and I believe that the court was correct in issuing the easement by necessity.
Thank you. 651, Ashker versus City of Niagara Falls. We have to wait for just a second. There he is.
Good morning, Your Honors. May it please the Court, Adam Delabovi for the appellant. There are two issues on appeal. First, that the city did not meet its burden to establish a lack of prior written notice. There is photographic evidence in the record that establishes the defect in question existed at least since 2011. The city submitted an affidavit that established lack of prior written notice from 2013 forward. There's at least a 2-year gap where we know that defect existed, and there was no showing by the city that there was no prior written notice. The second department cases that the respondent relied upon, showing a 2 to 5 year look back period is sufficient. Those cases are different from the case at bar because here we know that that defect was in existence. Moving forward to the second issue, the prior written notice law was invalid because the statutory designee did not exist and had not existed for decades prior to this incident. The prior written notice law was impossible to comply with. Therefore, it is the appellant's contention that the relevant law is the state law, the Second Cities Law, Section 244, which allows a showing of constructive notice to establish notice on the defendant. If there are no questions, I will rest on the remaining of my submission. Thank you.
Thank you.
May it please the court, Mark Delaposta on behalf of the city of Niagara Falls.
Mark, Mr. De La Costa?
Yes.
Could you, excuse me, could you address the
You just
2-year?
did it.
I know.
This is a free-for-all.
The 2 years that council brings up, what's the significance of that, if any? I'd like to know.
The significance of what, Your
Okay,
Honor?
the 2-year period.
Oh, okay. It's not significant for a couple of reasons, Your Honor. First of all, what he's arguing is that a Google photograph from 2011 should rate as constructive notice to the city of Niagara Falls. That's not the way the prior written notice statutes operate. 5.14 specifically says prior written notice to the Director of Department of Public Works in writing before the accident. That's the only way you can establish liability unless there's an affirmative act or a special use, which don't apply here. And that's been upheld by this court in Oswald, in Godago, and in Christie.
So it's conjunctive, lack of prior written notice, you know, I guess I'm trying to figure out if that is a difference that matters, that council brought up. That from 2013 on, there was some notice the city was able to prove that there was no prior written notice. But he's saying if you go back to 2011, there was notice. And I'm trying to figure out whether that's important or not.
It's not important, Your Honor. The reason is we have testimony, an affidavit, and copies of the prior written notice log from John Kinney, the Director of Public Works, that says there was no prior written notice given for this 1873 Linwood Avenue before this accident happened in August of 2018.
Okay. Go ahead.
If you look at his, I think we've gone above and beyond in making that showing, because if you look at his affidavit, not only do we have 25 pages of prior written notice logs, over 200 entries showing that 1873 Elma was not mentioned, but beyond that, we have Exhibit B to his affidavit at 413 of the record, shows 9 separate index card entries saying that there was no prior written notice dating back to 2004. So a search was made, he testified, and this is what he came up with: no prior written notice, and he gave you 13 or 5.5 years worth of his logs, but also the no prior written notice on they did an entire search for all of Linwood Avenue in Niagara Falls, and it went as back as 2004, and that's attached to his record. Those are cards, those are records that show that. In addition, Your Honor, Mr. Delbovi and I, and this is in the record, on February 22nd, 2022, both went to the Department of Public Works, examined the records, looked at the records, gave them the opportunity to actually look at the records, in addition to supplying them to this court, both in index cards and prior written notice logs. So they have not met their burden. We have met our burden. The cases that he cites are relevant. The cases of where you need 2 years, 3 years, or 5 years, according to these appellate division cases, there's no argument or there's no authority to the contrary saying you don't need that or you need longer than that.
But you're saying that you have it anyway, so it doesn't matter.
I'm sorry, Your Honor?
You're saying you have it anyway, so it doesn't matter.
Right, we have it anyways in terms of the cards, in terms of the log, in terms of the testimony. So, and this court has upheld this prior written notice statute on several, his second argument, the prior written notice statute has been upheld on several occasions by this court. It's a home rule. The Second City's law, which wasn't raised at the court below, by the way, it's raised for the first time on appeal, that does not apply because it's a home rule. 5.14 supersedes the Second City's law, second class city's law. So unless there's any other questions.
Thank you.
Thank you, Your Honor.